terms of an extension agreement which hasn't been registered, of which he does not have actual notice, and to which he does not consent. And that certainly in cases where the mortgage is amended and extended after the registration of the second mortgage. I think the Reynolds case says that there's no windfall. The subsequent encumbrancer doesn't receive any windfall, but the prior the prior mortgagee cannot claim his increased interest in priority over the interest of the subsequent encumbrancer. That case also says that the subsequent mortgagee is entitled to have the prior mortgage paid off according to its terms. The second question is that if when the subsequent encumbrancer originally placed the mortgage on title, the prior mortgage had an original balance of $10,000, and 3 years later the balance was $100,000 was $92,000. But the rate was increased without notice from 10% to 18%. I think the answer is the same, is that the decrease in the principal would have been much greater had the interest rate been lower, and he's also prejudiced by the fact that when he acquired his interest in the property, the prior mortgage provided by its terms it was to be paid off on a certain date, and he's entitled to insist on that.
Ross?
The first question I have also relates to the Reynolds case. Regarding short-term mortgages and renewals at higher rates of interest without registered or renewal agreements. Many of the standard forms of mortgages in use contain a provision that the mortgagee may renew the mortgage at a higher rate of interest and extend the term, thus providing notice to any subsequent encumbrancers of the possible higher rate. Is this effective to preserve the mortgagee's priority for the higher rate of interest? I think that most of the stationers included this clause after the decision in Reynolds extrusion. The court seemed to indicate, although I think it was obiter, that these clauses might work. But I think the difficulty, and certainly you're better if you're drafting it and you intend to rely on it to insert the clause than to omit it. But let's say the mortgage was at 18% and the mortgagee then extends the term and increases the rate to 20%. I have real doubts whether this kind of a clause would constitute actual notice of an interest rate at 20%. I think it's certainly actual notice that the parties agree perhaps in the future to increase to a higher rate which might be specified, and there may be some form of constructive notice, but I have some real doubts whether that clause would constitute actual notice. I think I'd certainly challenge it if I was in a position as a second mortgagee.
Nancy?
Question with respect to the Royal Bank VRM, variable interest rate mortgages, what assurances does the borrower have that the loan will not be called even if there is no default in monthly payment? Well, the simple answer, as I see it on the disclosure statement that has been handed out with the materials, is in paragraph 8, which does provide that and this, by the way, is shown is to be executed not only by the borrower but by the bank. It does show that the loan would not be called as long as there's no default by the mortgagee in making the payments provided for in paragraph 5, which provides that he can make certain monthly payments. So I suppose that's the assurance in that connection.
Marty?
If a demand promissory note calls for interest at 12% per annum, but in the event of default 18% per annum, what rate of interest is enforceable after default? I assume that this does not relate to a promissory note that's secured by a mortgage on real estate. If it were, Section 8 would apply, and 12% would be payable after default instead of 18. But if we have simply a promissory note with no land being secured in respect thereof, we have to go to the common law. Falconbridge, in his text, states that the position of common law is really the same as under Section 8, that the courts of equity would consider that provision to be a penalty and would not enforce the 18% contractual arrangement. On that, one might consider whether, if it's really the rules as to penalties that apply, whether one could provide, instead of 18, the prime rate in existence at the time of default, and have the parties agree that that would indicate, that would relate to a honest, genuine pre-estimate of the damages that would be suffered by the lender, which would in fact be the case, whether that would in fact be successful. The other route that Falconbridge suggests, as has been pointed out by Rudy, is that all you have to do is say, I'll pay you 18%, but if I pay on time, I'll only have to pay you 12. Falconbridge clearly says that that is effective, but the Weirdale case suggests that you can't get around the substance of it by virtue of the form.
Rudy?
This is a case dealing with, or a question rather, dealing with signing default judgment. I gather it's default judgment on a claim on a covenant for payment in a mortgage, but signing the judgment for the legal rate of interest rather than the rate in the mortgage. And the question is the practice of the registrar correct in granting interest under the Judicature Act on judgments for payment on mortgages at a rate different than the mortgage in view of the section, I think that it's the section which says it does not apply where interest is otherwise agreed upon. Now, I would think that this, as I mentioned, this would deal only to default judgments where the mortgagee is proceeding by way of a specially endorsed writ, and he simply signs his judgment before the registrar on default, and there's no real judicial determination of any issue between the parties. It's a default judgment. But I would think that the mortgagee is not entitled to sign interest at the increased rate. The mortgage contract will almost always provide that interest is specified before and after default or before and after maturity. And I think that the contract itself, therefore, provides for the rate of interest which can be charged after default. And I also don't see how Section 8 can be ignored, particularly if Weirdale is, the Weirdale case says that that's going to be interpreted very broadly to afford the protection intended by the statutes to a mortgagor and not to be looked at on a strict interpretation basis. So I've only seen one default judgment where the interest rate has been at what is called the legal rate, and it was substantially higher than the mortgage rate, but I don't think you can do that.
The one, Marty, the one comment that I'll make, if you look at Nancy Carnwath's material, you will see that there was a provision, and there are cases that have held that where the mortgage does not stipulate that the same interest applies after judgment, there is a merger of the mortgage debt in the judgment. And the courts could then go on that if the mortgage did not provide otherwise, once judgment was issued, you could get the statutory rate of interest. But as long as a provision is contained in the mortgage that the same rate would apply after judgment, then only the rate that's stipulated for would be applicable. Ross?
Some variable rate mortgages are structured as being collateral to promissory notes. Because the loan in effect is a personal loan secured by land, or I guess a mortgage of land, can the loan be considered as fully open without notice or bonus, and if so, on what legal basis? I don't think it matters as far as that issue is concerned, whether you have a note secured by a mortgage or whether you just have the mortgage. You'd have to look at the terms of the note and the mortgage to determine whether they're open, and if so, on what basis. The one point, though, most of the transactions that are structured in that way, with a note secured by a mortgage, are payable on demand. And I think the converse to the right of a mortgagee to pay on demand is the right of the mortgagor to prepay. So perhaps that was what the question was getting at, but I don't think it matters whether that demand is in the note or whether it's in the mortgage. One comment I will make on variable rates in promissory notes: there was under the Bills of Exchange Act, a promissory note is defined as an unconditional promise to pay a sum certain in money, and it has been held by the Court of Queen's Bench in Saskatchewan last spring that a promissory note which provided that the interest was payable at 1 3/4% per annum above a particular bank's small business base rate was not a sum certain, because the court could not determine the interest payable by looking at the face of the note. As a result, it was not a promissory note within the meaning of the Bills of Exchange Act, so that the provisions of the Bills of Exchange Act would not apply to it. However, it was still a contract and a promise to pay, and therefore it would still be enforceable. That decision was Bank of Montreal and AM Investments, but I'm not aware whether it's reported yet.
Nancy?
Demand notes are now using the prime plus wording rather than plugging in a fixed rate. Why have they now changed? Well, I think the change has come from a changing opinion as to whether you can use a floating rate in a document. A number of people had come to that conclusion even before the British Pacific Properties case, which Marty referred to in his lectures under Section 3 of the Interest Act, but that case has certainly given a lot of confidence to people using the fluctuating rate. And it's much more convenient for banks to be able to put in a fluctuating rate than rely on the old principle that they had to demand the higher rate, get it accepted before it was legally binding on the customer. Also, if the customer didn't accept the higher rate under the old demand loans, until they got judgment, the rate ran at the rate set in the note, which in an increasing interest climate was not very good for the bank. So because of the rising interest rates, it's become much more important to be able to use the fluctuating rather than the fixed rate in the note. And because of the British Pacific Properties case and the other line of cases, the banks feel they can do so with impunity.
Marty?
I've got a question. The provisions in the Kilgorn and other cases discussed that dealt with the blended interest question seem to be any plan that involves an allowance of interest on stipulated payments. Your comments, please. As I mentioned, there are 3 types of plans referred to in Section 6, which give rise to the requirement, if one of those plans are in your mortgage, give rise to the requirement that the statement as to the interest rate calculated yearly or half-yearly be present in the mortgage. I mentioned that the courts have not yet told us what they think comes within the wording of a plan dealing with an allowance of interest on stipulated payments. The closest, the most help we have is the Einat and Wetson case, which is footnote 10 of my materials, in which there was interestingly enough, a floating rate mortgage. It clearly wasn't a blended mortgage because there were payments of interest only until maturity, so that's another way to get around the whole question of Section 6. Don't provide for any payment that has a combination of interest and principal component, interest only until maturity. And the court was asked the question whether or not the formulation of interest and principal payments came within this other type of plan, one that involved an allowance of interest on stipulated payments, for the reason that on some prepayments of principal, the mortgagor was allowed a reduction in the interest that he had already prepaid on that principal that he is now prepaid. And the court said that they're not sure what that kind of plan is, but it was clearly not what they had before them. I would have thought that an allowance of interest on stipulated payments means something that has to go back to the mortgagor. So he's given a credit for something. And in all the mortgages that we've discussed, certainly the ones in the cases, and the ones before us, and the ones that we see in normal practice, the mortgagor is always paying interest, and only interest that has in fact accrued, that has been earned by the mortgagee, and therefore I can't think that we'd come within that plan.
Again, having no questions, it's such a pleasure that you didn't bother asking me anything. I'll pass it to Rudy.
Can a mortgagee charge 3 months bonus of interest where a mortgage has matured and the mortgagee takes no steps to realize on its security? I'm not certain how the mortgagee could charge 3 months bonus of interest if he's not taking any steps to realize on his security. In any event, I think that that would offend Section 8 of the Interest Act and would be prohibited. Again, I just mentioned that reference to Section 16 of the Ontario Mortgages Act by Madam Justice Van Camp in the Parkhill and Moyer case, where she appeared to hold that as long as the mortgagee is proceeding to enforce payment, he cannot claim and is not entitled to any bonus. But if the mortgagor, prior to the mortgagee taking steps, attempts to pay the mortgage off, that the mortgagor is then required by Section 16 to pay 3 months interest as a bonus. But I can't see how a mortgagee can get around Section 8 and trying to charge any kind of bonus or surplus payment as a result of default, where that has the effect of increasing the rate of interest on principal money, which would be payable if principal was not in arrears.
Ross, would you take the last question?
You referred to the deemed reinvestment principle. Didn't the Supreme Court of Canada in Marenish hold that such principle does not apply in Canada? I think certainly the press indicated that when the decision was handed down, the deemed reinvestment principle did not apply, but I'm not sure that's right. And I think you should certainly read the case, but I'll tell you what my view, and I think you've got to read it in conjunction with the Court of Appeal decision as well to understand it well. My own view is that while in Marenish, the mortgage itself did not specify the frequency of calculation of interest. It did not say that it was calculated monthly or calculated annually. The Court of Appeal then drew on all the cases that were decided under Section 6 and 7, Section 6 being the one that says if you've got a blended payment, you have to put in a statement showing the interest calculated annually or semi-annually. Because the sanction for a breach of Section 6 is so drastic, namely no interest, the courts leaned over backwards in those cases, I think, to try and ensure that the mortgagee would get his interest and not lose his interest merely because he made an innocent mistake of leaving out that statement. So these cases say that if you don't put a statement in, then the courts will deem that interest is to be calculated annually, not in advance. Annually, because that's the lowest yield to the mortgagor and the least cost to the mortgagor. The Court of Appeal drew on those cases to say when you leave out reference to the frequency of compounding, then it's deemed to be calculated or compounded annually. Once they got to that stage, they had to say because it's payable monthly but compounded annually, the deemed reinvestment principle applies. The Supreme Court of Canada said that these cases under Section 6 and 7 were not applicable to this issue, and that if the mortgage is silent on the frequency of calculation of interest, then interest is not deemed to be calculated annually, as the Court of Appeal said, but it's deemed to be calculated when interest is payable. As soon as they reached that conclusion, then they were able to say that because interest was calculated and payable on the same date, the deemed reinvestment principle did not apply. They mentioned that the deemed reinvestment principle was not a principle of law, which is correct, because the deemed reinvestment principle is a mathematical principle. The case, I think, the decision is a little, not totally clear, and that's a little bit unfortunate, but I think we're certainly trying to protect ourselves against the deemed reinvestment principle, and I think there's 3 ways to do it. One is to exclude the deemed reinvestment principle by contract. Secondly, you can exclude it by providing that interest is calculated and payable on the same dates or with the same frequency. Or thirdly, you can leave it out and attempt to rely on Marenish. But if you leave it out, then, and you're dealing with a variable rate mortgage, then you don't have the same kind of protections that Kilgoran and Samick and Tilson and Doherty provide. So I think it's certainly better to put it in.
And I think it's time to call it a day. Thank you very much for your patience.